we live? Yes, here we are. We are live. Good afternoon. Buenas tardes. The instinct is to always address the audience in Spanish, but this is our first English language podcast with attorney Thad Servi from the offices of Vasquez and Servi. My name is Brenda Bueno. Welcome, abogado. So happy to be here finally.
Thank you. Thank you, Brenda. I'm Thad Servi. I'm a managing partner here at Vasquez and Servi. And everyone here speaks English and Spanish, but we realize that we've been doing shows for 10 years or more.
Yeah, longer.
In Spanish, and it's time to do it in English, especially for everyone out there who's got DACA now prefers English over Spanish.
Of course. I think it's been a long time coming. There's a lot of content for the Spanish community and of course the immigrant community in general. Just that for now, we want to focus on a lot of different topics. I mean, immigration is a hot topic now. It can be very confusing, very painful, heartbreaking as well. So I think that more than ever, it's time for people to be able to, understand in their language. A lot of these people were brought to the U.S. super young, few months old, a few years old. They've become professionals, they've had families, and so they've lived here, the greater part of their lives, but they don't always understand. I mean, how can I help my boyfriend, my girlfriend? How can I, get out of a DACA status and go into something permanent? How can I help my parents? I'm a U.S. citizen. Or if you're a U.S. citizen that's in a relationship with an immigrant and you don't even know the first step, that's what this space is for. So we're happy to be here, Attorney Thad Servi, Brenda Bueno. So we're going to get started. I mean, just let's go over some basics, Attorney Thad, and then of course we're going to share. Ask everybody that's watching this video, please share so that we can reach as many people as possible, because this content is very, very necessary. So what are we going to talk about today?
We're going to talk about marriage-based petitions and the reality of fixing your papers based upon marriage, the myth of having a child that turns 21 and petitioning a parent because it's not as easy as it sounds, military parole in place, and how that's kind of like a hack to get past this situation where the person who wants to have lawful permanent residence came into the United States without status, DACA upgrades such as advanced parole to unlock a green card. And we're going to demystify some of these things, the permanent bar versus the 10-year bar, and for which there's waivers available for both, but the permanent bar is much more difficult. UV says removal defense and what to do if ICE knocks on your door. Naturalization, which we can call that, is the ultimate protection, although a lot of people have heard that this government is trying to denaturalize people.
Right.
And remember, during this whole show, please send us questions. If we don't get to them today, it's going to be a great topic for the next show, and we'll address all your questions. If it's not this show, because it's only 30 minutes, it'll be to the next show.
Of course. And Attorney Thad, I think one of the main things is specifically DACA related. DACA has been in the, hanging in the balance. It's been in danger a lot. They stopped taking new applications, but DACA has saved, 500,000 or maybe more immigrant children that came to the U.S. Through no fault of their own before they turned a certain age. So DACA has protected them, if you will. They have a work permit, they have a social security card, and most of them licenses and decent jobs and whatnot, and families. So if someone says, okay, I don't feel safe enough with the current climate, I don't feel safe enough with DACA. Can I still be put into immigration detention? Can I have an ICE hold? Can I be deported? How can we move from a DACA status to a permanent resident status?
Excellent question. So let's distinguish for people that have DACA and break it down into categories. Those who entered the United States with inspection versus those who entered without inspection. So if you entered with inspection, that's kind of the key to adjusting your status based upon an immediate relative. And when I say immediate relative, that means that your spouse or your child who's over 21 is a United States citizen and is going to petition you. Of course, there's other people. For example, your parents can petition you, but if you're over age 21, especially from Mexico, it's going to take a long time, decades. And your siblings can petition you. So with DACA, think of it, the most common thing is this. I have DACA, I'm married to a United States citizen. Well, first of all, did you come into the United States with inspection? Because if you did, we can apply for adjustment of status inside the United States. Okay, so that is the I-485 application, and you get a work permit with that. And it usually takes somewhere between about 6 months to about 2.5 years with this administration. So we're seeing that move forward very quickly. But what does it mean to come in with inspection? So when people come into the United States with a visitor visa, tourist visa, that's inspection, and they're admitted in a visitor status. That's a very common situation. But also a lot of times what we're doing with people is helping them get DACA-based advanced parole. Okay, so they leave the United States typically for a humanitarian reason, such as to visit a sick relative. And when they come back, they pass through inspections and they're not admitted, but they are paroled. And that allows them to adjust status based upon the immediate relative petition, whether that is through their United States citizen spouse or their United States citizen child who is now age 21.
Okay. So, of course, that's a huge difference. A lot of people assume that those that have DACA status all came in illegally, but no, there's people that came with their family as tourists and they decide to stay in the U.S. Now, another common thing that happens with a lot of the DACA recipients is, okay, I am now in a relationship with someone who's a U.S. citizen. So will the difference between them being able to adjust here in the U.S. and having to go to their country, will it be specifically that advanced parole? Because some DACA students or some DACA recipients haven't tried to get advanced parole. Some of them don't know what that means. That's going to make a difference, attorney?
Yes, it will. So if you did not come in with inspection, and the typical example is with the visitor visa, the tourist visa, the advanced parole makes all the difference in the world. Okay, if you can execute the DACA-based advanced parole, and basically it's going to require an ailing relative abroad, and we get doctor's letters and that sort of thing to establish that, and we show the family connection, that it's just not like, oh, thank God I've got a cousin who's sick. No, we want it to be aunt, uncle, grandparent, parent, something like that. Sure. And so they're going to go and visit that person because that person is very sick and come back into the United States. And from that is the inspection and parole, and we're allowed to adjust status inside the United States based upon the family petition.
So that's your legal entry.
That is a legal entry at that point.
Great. Some people are scared. And with the current climate, how often do you guys see that DACA recipients are being denied the advanced parole?
I've not seen it, but caveat, okay, this
Sure,
is very important.
Sure.
Ever since the Trump administration came back into power in the second term, we've not seen the DACA-based advanced paroles being approved. Not to say that they're being denied, but they haven't been approved either. So there are class action lawsuits starting to push USCIS to adjudicate those cases. And there has been an announcement by the Trump administration that they're going to apply that humanitarian factors or that evaluation much more carefully and much more seriously than in the past.
So the good thing is that if the advanced parole request is accepted, now that means you can go to your country for a humanitarian reason or whatnot, and you will be allowed to re-enter. The fear is, okay, I can leave, but how do I know they're going to let me come back in?
So I will say this, that I've not seen anyone be denied entry with parole.
Great.
Okay, that's a very important thing. I'm not saying it's without risk. Anything is without risk, including not taking a step forward.
Right, that's true. So now another thing that's common with the DACA recipients, like we had mentioned, okay, a lot of them have children already. They're professionals. They're married to possibly a U.S. citizen. Let's assume that a DACA recipient has a U.S. citizen spouse, and they have done their advanced parole. They were able to leave, go to their country, make the legal reentry back. Is that pretty clear shot? How long does that take for them to adjust?
It's pretty clear. So I will say this also, if someone has a very recent marriage, actually we're seeing those cases being set for interviews much more quickly.
Nice.
It appears as though the government wants to try and ferret out any fraudulent type marriage, some marriage that's just based on immigration status rather than trying to form a family and have a true relationship as husband and wife. So those cases, we're actually seeing them being set for interviews in 6 months, 7 months, 8 months, 9 months. Now, it takes longer to get the approval afterwards, but we are getting the approvals.
Great.
We're not getting a denials based upon
Great.
that. We're not seeing people being placed in removal proceedings. And, you know, we have many cases. Just so everyone knows, we have 6 attorneys here. We have a team of about 30 people.
Great.
And so it's not like I have a few cases to look at. We have many cases to look
Sure.
at.
And we thank everybody that's sharing. Please continue to share the video more than once. We do have a question from Margarita who says, well, what can we do about this? Advanced parole. It's been a year and it hasn't been approved. What's the next step?
Margarita, my heart goes out to you, but you're going to have to wait, you know, on this thing. You're doing what you should have done, which is applying for the advanced parole. And now you just have to wait. Again, there is a federal lawsuit, a class action or a mass action. Okay, so the difference between that is a mass action is basically there's a lot of plaintiffs. But if it's a class action, it's been certified as a class and it's going to apply to the entire class of people who might be in that class or not. We think that we're going to be prevailing on that. It's not my firm that's doing it, but it's a group of immigration attorneys. We have groups of immigration attorneys, such as the American Immigration Lawyers Association, who sometimes take up that charge.
Wow. Attorney Thad, I know that, I mean, DACA is a huge thing. It's been, like we said earlier, protection for, probably, several 100,000 of, young immigrants, and a lot of them have made their life here in the U.S. Now, one of the huge things also, and point number 2 on our list here, and we want to welcome everybody. Bienvenidos. Thank you so much. Moms, dads, anyone that speaks English, anyone that speaks Spanish, gracias. We're here with Pa'lante MiGente, which we say in Spanish, together with our people, but today we're going to, forward together?
Forward together, yes.
Forward together. Now, here's a huge one, and I think that many people are like, okay, I just turned 21, or I turned 21 a few years ago. How can I help my parents? I thought that once a U.S. citizen turned 21, if their parents had no status, don't they just magically get a green card, Attorney Thad?
Wouldn't that be wonderful? But no. So again, this is going to come down to the parents and how they entered the United States. Did they enter without inspection? Did they enter with inspection? If they entered with inspection, then we can submit the family petition with the adjustment of status, apply for work permit, and we're going to move forward with the adjustment of status inside the United States. Just so everyone's clear, this is not as easy as it sounds. You have to have a complete evaluation and look for any traps on the case. They're going to come in. But that is the big difference. And so that's going to cross over into military parole in place, because we have a lot of young people who are making a sacrifice, and some people just say, I want the military career, but they're joining the military so that their parents can apply for military parole in place. And with that military parole in place, then it's the equivalent of having been paroled, even though you didn't leave and come back. And you're eligible, you're on equal footing to apply for adjustment of status inside the United States.
Great. So that's one of the first steps. I mean, obviously, it's not as easy as it sounds. It's very different for example, a U.S. citizen that's 21. Like you said, if parents came in with a visa or with some kind of even work visa, some parents come in to work in agriculture, or some come in for other reasons. Now, if they came in with, with inspection, totally different. But let's just say the great majority, they were born in the United States. These young people born in the U.S., mom and dad came in illegally, undocumented. I mean, do my parents have to go back to their country? And how does that work? And how long do they have to be gone?
Sure. So in that situation, if someone comes into the United States without inspection and they're here, they're not eligible to adjust status most of the time. I'm going to quickly explain an exception to that. It's called 245I, where if someone submitted a petition on their behalf before April 1st of 1997, they're eligible to pay a penalty of $1,000 and adjust status inside the United States. And we will look for those things. They don't have to be the direct beneficiary. For example, perhaps one of your uncles applied for your parents or your grandparents, one of your grandparents' siblings applied for them, and your parents were derivatives. So in that situation, they're grandfathered in many situations, and they just pay an extra penalty of $1,000. Now, if someone came into the United States without inspection, it's not impossible to secure lawful permanent residence through consular processing, but you have to apply for a waiver or you have to wait outside for 10 complete years.
Oh, wow.
Yes. So we're experts in waivers here. It is, bread and butter of our practice. And so to qualify for a waiver for entering not specifically for entering the United States without inspection, but for being here more than 1 year.
Right.
Okay. Because remember, you're going to have to leave in consular process. So at that point, you have to have a qualifying relative, and the qualifying relative can only be a lawful permanent resident or United States citizen, parent, or spouse.
Okay.
Okay.
And see, that's the kicker. Here's something that's huge that I love this space where we can talk about this, because those that don't have an immediate need to adjust status, for example, people that were born here, they have no idea. So you mean to tell me, Attorney Thad, that it's not enough for me to say, okay, well, I'm 21 years old, I'm a citizen, I want to adjust for my parents, and I've got two little brothers and sisters that are 7 and 10. So why does my mom and or dad, why do they have to leave the U.S. if they have two small children that depend on them? So, how do we get past that? So young children, minor children born in the U.S. aren't enough to keep parents here?
No, not with the family petition consular processing. Okay. They're going to have to wait out for 10 years. Now, there is another law that we'll talk about, cancellation of removal, that applies to people who are in removal proceedings. It's a very steep hill to climb with that. But we'll talk about that in a little bit.
Sure. Obviously, we'd like to thank everybody that's sending messages. Thank you, Sharon. Thank you for all the messages. Thanks, everybody, for letting everybody else know about this ahead of time. We've been promoting this for a minute. So the myth about the bar, like when they say, okay, so I want to adjust for my parents, they have to leave. If there's not a way for them to come back with, like you said, it's not enough to have minor children that are born in the U.S. They would have to have one of the spouses have status, and or a parent to have status. A parent, in other words, a grandparent of the U.S. citizen child. But for example, how do I know if my parents have to be gone for 10-year versus permanent bar? Because we hear that a lot get thrown around interchangeably, but they're very different.
Yes. Okay. So the 10-year bar is basically going to apply for people who have more than 1 year of unlawful presence, but did not then leave and come back to the United States unlawfully. Okay. Or if they had a previous order of removal and they left and came back unlawfully. That's a permanent bar. And for that, you have to be outside of the country for 10 complete years. And then you have to apply for something that's akin to a waiver. And it's a Form I-212. And you have to show family unity, that you're not a danger to the community. And those are the two basic things. But you want to show some good moral character in there, like paying taxes and that sort of thing, sure, too. But that's a tough situation right there. A permanent aggregate bar. So that law started on 4/1/97, okay? And that's when unlawful presence started. So if someone was here prior to that time and left and came back in before that date, they're not going to have the permanent aggregate bar. But if they stayed here after that and they have to leave the consular process, they are going to have the 10-year bar.
Wow. So we're live right now. If anybody has questions, please type them into the comment section. Thank you so much for everybody that's watching. Now, here's something huge, and this is not only for U.S. citizen children of parents without status, also U.S. citizen fiancés and spouses. They're like, okay, so I'm a citizen. Let's just say I married my immigrant spouse. I am a citizen. Shouldn't I just be able to petition for them? Now, there's a lot that goes on way before these processes, and a lot of things that sometimes spouses and even U.S. citizen children don't know. It also depends on how many times has your spouse or mom or dad, how many times have they tried to come into the country? Have they been caught at the border? Have they been arrested for driving under the influence? So criminal history, Attorney Thad, immigration history, because, when someone tries to come across the U.S. Border into the country 3 or 4 or 5 times, and they get caught 3, 4, or 5 times, that's a huge thing. And sometimes your children don't know how many times mom and dad tried to come across, or your brand new fiance hasn't told you everything about his or her past. Some people run into these obstacles without really knowing what they're getting into, right?
That is true. And so that kind of illustrates the necessity for an appointment, because I've had people who've been caught at the border 8, 9, 10, 11, 12 times and they become lawful permanent residents.
Right.
Okay, so there's a big difference here. When you're caught at the border and you had horrible luck and you try to come in once and you get caught and you get kicked back, a voluntary return, but not an order of removal. And you sleep on it, and the next day you come back, or a few days later you keep trying, try again, but you finally enter the United States successfully. Okay, but each of those times that you came in, if you came in without inspection, without presenting fake documents or something like that, these are just voluntary returns. Okay, so again, it's not that you get caught trying to come into the United States twice, 3, 4, 20 times. It's if you were here more than 1 year unlawfully after April 1st of 1997, and then you left and you came back, and then oftentimes people are caught at the border at that point, and it establishes very clear evidence that that person left and came back. That's the permanent aggregate bar. That's one of the big problems.
Wow. Now, Attorney Thad, we're getting a question, some of these coming in through inbox, and this is very interesting as well. Okay, so I'm a U.S. citizen, born in this country, and we have a blended family. So prior to this U.S. citizen, child being born here, brother, sister came in illegally with mom and dad. Maybe mom and dad won't be able to adjust, but what about me being a citizen? Can I petition for my undocumented sibling and or a sibling with DACA? So a citizen can petition for a DACA sibling or an undocumented sibling?
Absolutely. United States citizens have the right to petition their siblings. Now, if you're from Mexico, it's going to take probably about 40 years. That's the reality of the situation. It's determined by a law that says there's this many visas available for this category, siblings, and it's divided into each country. So for Mexico, it's the longest. For the rest of Latin America, it's still probably going to be about 20 years. But yes, you can petition them. Oftentimes what we're trying to do in that situation is see if we can help mom or dad first, because it's almost always faster for mom or dad as a lawful permanent resident to petition for a child. Now, if that child is from Mexico and that child is over 21, it's still going to take a very long time, but it's still much shorter, especially if you're from one of the other Latin American countries.
Wow. So now for those that have like you said, that come into the country and they were super young, does their, I guess their time or their illegal presence start counting when they came in or when they become adults? What age does it begin?
Okay, so this is a bit nuanced. So if they came in under age 18 and they were here on April 1st, 1997, that's when unlawful presence starts to accrue for the 10-year bar.
Okay.
Now, if they were here, if they're brought to the United States at age 1, and then their parent after April 1st of 1997, but then their parents took them back a year or two later and brought them back again unlawfully, that's still unlawful presence for the permanent aggregate bar. So it's a bit tricky. Okay.
Sure.
We have to look at each case individually.
Sure. Now, for those that have DACA and they are in the process of maybe getting engaged, they're going to get married. If someone has DACA, Attorney Thad, should they just say, okay, well, now that I'm going to marry a U.S. citizen, my path is becoming a little bit clear, but should they never let their DACA lapse or expire?
Never let your DACA lapse or expire until you become a lawful permanent resident.
Okay.
Okay. That's pretty clear, because things can go sideways with an adjustment of status application, especially with this government. And I, clearly I've been doing this, for nearly 3 decades now. Sometimes marriages also go sideways.
Right.
So the DACA is your insurance plan. It doesn't cost that much to continue to renew it. You're probably going to have to renew it once or twice maximum. If you're applying for adjustment of status, keep renewing it.
Okay. Now, of course, anyone who's in a process like this, again, they have to be forthcoming. A lot of people are saying, but what about if they had prior arrests? What about their criminal history? Now, interesting. They want to know, does the criminal history of the U.S. citizen spouse have anything to do with him petitioning for his immigrant spouse?
Very rarely. Okay, there's a law called the Adam Walsh Act, and you can imagine this basically is prohibiting sexual predators, those who are on the federal sexual registry list, from petitioning people, and there are exceptions to it, but it's very difficult to get past that. I've only seen those cases a couple times in my career, fortunately.
Right, fortunately. So again, I mean, this space, there's so much content that we can touch on. I mean, of course, people asking anything from, okay, I have DACA, how do I become a permanent resident? And demystifying about the bar. Of course, obviously, there is something that happens more often than we'd like. And for example, if someone has DACA and they're like, okay, I'm protected, I have a work permit, I have my social security card, I can work, I can drive. Now, if a DACA recipient gets in trouble, can they be put into ICE detention? A lot of people do feel like, well, I've been here for 28 years. I have my DACA. I feel pretty safe. But if they do get into trouble with the law, depending on what it is it true that even DACA recipients or people with TPS and some of these asylum, can they still be sent to ICE detention?
Let's break it down with DACA first. The answer is clearly yes for all these categories, but it's unlikely if you have DACA. You hear these worst case scenarios in the news sometimes, like the lady who was in Texas and she's driving home from school with her kids or
Yes.
something like that, and she hit, say, an ICE vehicle, and she got snatched up and put in removal proceedings very quickly and sent to Mexico. She's coming back. Almost certain about that. They're bringing her back. But you don't want to be in that situation, and it's rare that you're going to be in that situation with DACA. The more publicity that comes out about these unjust situations, the better it is for the rest of the people. I'm very sorry that lady had to go through that, but it's not for nothing. She's, that news story has helped out a lot of other people who did not get put in removal proceedings because of all the pressure that was put on the government about that ridiculous, unfair action that ICE took. Now, when we talk about TPS, yes, you can still be put in removal proceedings. And remember that TPS is basically gone for almost everyone. Salvadorans still have about a month left. And I don't think that, that we're going to see extensions of TPS for El Salvador, although we've not heard yet. But yes, people who get into problems, especially criminal problems, it doesn't matter if you're lawful permanent resident or not. If the crime is serious enough, doesn't matter if it's TPS, asylum, or DACA, you're going to be put in removal proceedings. Now, asylum is its own special animal. So if you have an affirmative-based asylum case pending and you are pulled over by the police and they call ICE, ICE is routinely taking those people and putting them into removal proceedings, okay? And I've had situations come up where, for example, a young lady who was applying for asylum was trying to travel by bus interstate from here to California to visit her fiance who's in the military, and she gets stopped, I think it was New Mexico or Arizona, and she's put in removal proceedings, okay?
Wow.
So because she has a U.S. citizen fiance in the military, hopefully she was able to resolve the situation, but she was detained in a different state. We did not take that case for immigration bond.
Wow. Now, attorney, one thing that pops up quite a bit on all of our Spanish language shows, and unfortunately it's all too common, a lot of people have also been given really bad advice as far as it's enough for you to have an autistic child. If you have DACA and one of your children has autism, he's 3, he's 7, he's 12, he's 20, you can stay in the country, you can adjust and jump to the next category of permanent resident. I mean, unfortunately, autism is at an all-time high, different levels on the spectrum, but people have this idea that it's enough to have a child with special needs and or autism. It's not necessarily that easy.
No, it's not. So first of all, where they're going at with these questions is basically like, I don't have status or I have DACA and I want to become a lawful permanent resident based upon this hardship to my child. So prior to the Trump administration, we routinely filed humanitarian deferred actions, which would help people that did not have DACA get a work permit. It was valid for 2 years, and we're renewing those, but we haven't heard back from the government yet. Now, if a person has a child with special needs and they're placed in removal proceedings, oftentimes we can apply for cancellation of removal. Now, in Spanish, a lot of times the community will call that la ley de los 10 años, the law of 10 years.
Right.
It's much more than that, but you do have to have 10 years physical presence in the United States, good moral character, meaning that you file taxes and you don't have any negative incidents with the police that are going to disqualify you. Then you have to have a United States citizen or lawful permanent resident, parent, child, or spouse. So you see what I included in there was a child this time.
Right.
But the level of hardship is different. So for a waiver, we have to show extreme hardship. But for cancellation of removal, we have to show exceptional and extremely unusual hardship. It's a very, very high standard, and we have to show that there's not care available in Mexico. So I've won those autism cases and cancellation of removal for Mexico, and it's going to be the same for other countries. I'm sure I've won some for other countries in Latin America over the years, but you have to show again that that there's not a sufficient level of care available, reasonably available, not that it's completely unavailable.
Sure.
Because if you have enough money in Mexico, yes, you're going to be able to get that someone to fly down and take care of your kid and live with you, like a professional teacher who has specialties in this, but that's not the reality for almost everyone. It's got to be basically impossible, and we can show that.
Right.
But let me say this also: there's different levels of autism. So the cases that I've won, I'm talking about kids who are barely verbal and did not get out of diapers until they're 10 years old or something like that. I'm not talking about a kid who has a little bit of trouble communicating with his peers and has trouble making friends. That's a different level. And of course, we're going to make the arguments that we have to make. Okay, I want to emphasize that. So if someone is placed in removal proceedings, they get pulled over in a traffic stop, or a license check that's basically set up to funnel people over to ICE.
Sure, roadblocks.
That sort of thing. Yes, we are going to try and fight that for cancellation of removal. And I've had cases where I've kept people in the country for 12 years.
Wow.
Even though I did not win the case in the end, I was able to get one. The one that I'm referring to it was dismissed. It was dismissed, but the person never became a lawful permanent resident. But still, that's a long time, to stay here,
Sure.
Raise your children to the point where they can go to university.
Sure. Now, we want to invite everybody once again that have logged on since we began. This is the first of our English language series, the podcast with Abogado Dad Servi, Brenda Bueno, Oxígeno Radio. So we want to make sure everybody knows we'll be back next Tuesday. Well, not next week, but we will be doing this Tuesday. Next week, we're kind of on a hiatus. There's some vacation going on.
Yes.
But as of, the following week, we're going to be doing this Tuesday, English only. Tell your U.S. citizen children, neighbors, friends, kids with DACA. Now, something that's very common, and please keep sharing the video, something that's very common that a lot of, maybe because they have DACA or maybe because they're U.S. citizens, they're like, well, I'm going to petition, or maybe she or he doesn't need it. But a lot of immigrants, Attorney Thad, are victims of crimes. And the famous U visa, people hear U visa being tossed around, and unfortunately, with a lot of these attorneys out of state that are doing fraud, we'll get to that another day, but a lot of people are hearing the term U visa and VAWA. What does that mean if you were a victim of a crime? Because some people can, move toward a permanent status without having to wait, 25 years or 35 years for a citizen brother or sibling to petition for them. So when you're the victim of a crime, what avenues are open to you based on how you came in and what your current status is?
Okay, so sure, the U visa is for victims of crime, and I'm going to describe those crimes in general in just a moment. But the thing that's wonderful about U visas is it provides for so many waivers. So if someone has the permanent aggregate bar, we can waive it inside the United States. If someone came into the United States without inspection, they're typically not eligible to adjust, we can waive it. If someone has a prior order of removal, a false claim to United States citizenship, problems with the police, and I'm going to say the caveat to that is, I don't see a lot of approvals, or I see much heavier scrutiny where someone has themselves been a perpetrator of a violent crime.
Sure.
Okay, so that is an excellent way for someone to secure, first of all, U status, but even before that, they're going to get a work permit, typically in about a year and a half. And it takes a long time now because there's simply also a limit on the number of U visas, 10,000 per year for the principal applicants. And so it's taking about 8 years now to get the approval of the U visa. But once you have the U visa, after 3 years, we can apply for adjustment of status. Okay, we can apply for spouses, and even when the spouse is acquired during the pendency of the U visa, we can apply.
So the U visa, we have to remember, it's going to depend on, the certification. That's the key that opens the door. Not
Right.
every law enforcement agency wants to sign these. If the crime was 10, 20 years ago, it's a little more difficult, correct?
Correct. And so one of our attorneys relocated and has been here with us a couple of years, but she was out on the West Coast in Oregon, and they were much more gracious with those certifications. But over here, we're dealing with Fulton County, Atlanta PD, DeKalb, Gwinnett, Cobb. And so each of them has their own little, restrictions or requirements on what they're going to do this. But you can imagine that you better get your request out within 5 years of the crime at the very minimum. And Cobb, it's a little bit more difficult. They're going to say, no, we want to make sure this person is necessary. This person who wants the status is necessary as a witness.
Sure.
Now, but also let's talk about some of these crimes too, because it's not any type of crime. A lot of times people will come to me and say, my apartment was broken into when I was gone, and I want to see if I can do this. That doesn't have an element of violence to it. So if someone breaks into your apartment and at that point you're very scared, because why wouldn't you be? But they pull a gun, they pull a knife, we definitely have a good case. But you see the difference there. That now becomes a armed robbery. Okay, and you can see that with that, there's a gun involved with that, and there's that element of force. Other things that we're seeing, sometimes we can get these certifications signed for people who have been victims of perjury or extortion. Okay, so perjury means that someone typically gets on the stand and lies about you. Okay, in a court proceeding. That's one example of it, but I'm also going to bring up this thing that happened with the attorney Alexandra Lozano out in Seattle, Washington,
Right.
where she was submitting a lot of immigration forms, and she was swearing under penalty of perjury that the things that were on the forms were true, and she had basically a system set up where they would make, manufacture generalized statements. Now that could be perjury right there. But also the promise that I can help you get status through this lawful process, and therefore she's pulling the money from you. That is extortion, and that's another basis. But you have to get the certification. So the word is that a lot of people are getting certifications from the state of Washington, the state attorney general. We have to take that on a case-by-case basis. But we do get a lot of those cases, and so if you've been a victim of something where it's typically a VAWA case, and it could be that firm, and I can name that firm because it's all over the news now, and she's been basically agreed to give up her license. But there are other firms who are copying that model.
Right.
And they're very aggressive, and anyone who opens their mouth and says, oh, this is a Lozano equivalent firm, they're being sued.
Wow.
Okay, they're being sued for supposedly saying something that's not true about that.
Sure.
About that firm. But I've picked up on those cases too, and I can see that some of those cases are not being filed nearly as strongly as they could have been because of that whole boilerplate type of thing. My spouse was mean to me, and I'm digging into these cases and I'm finding out, oh, that spouse wasn't just mean, that spouse was absolutely horrible. And saying horrible things about the spouse in front of other people, on occasion pushing and grabbing the female spouse very hard and subjecting her to his brothers and family and that sort of thing, and receiving verbal abuse and demeaning behavior. So we can construct a much stronger case if you're in that situation and think that your case has not been prepared properly.
Sure.
So
that happens a lot too. That could be a topic for one entire episode. Now, before we do log off, we've got another question. If I'm renewing my DACA, but I haven't been approved, and my current one is expired already, am I accumulating a lawful presence? How will it affect me later on if there's an adjustment of status?
okay, so not so much for the adjustment of status. If you're eligible to adjust status, it's not going to matter. But if you have the consular process, that lapse between one work permit and the next is an accumulation of unlawful presence. So when you go to consular process, you have to be aware of that, because you might need a waiver. Again, we're experts in waivers, but we want to avoid that situation. Very quickly on that, we're starting to submit writs of mandamus, federal court actions. We're suing the government to say approve this person's DACA.
Wow. Now that's another thing, and we can close with that. Now we just want to remind everybody, don't panic. We are going to skip next week, but we'll be here Tuesday evenings around this time, 6:30. Attorney Thad Servi, Brenda Bueno, Vasquez and Servi, please write down the number that's on your screen. Keep sharing the video. We want so many people to see this, so they're like, wow, finally all these questions that I had, and I would listen in Spanish, I can't understand. So this English content, this podcast we're starting today, Pa'lante MiGente in Spanish, it is forward together. Please share, please tell everybody that you know. With the exception of August the 11th, we'll be back on the 18th then. So Tuesday the 18th, we'll be back with another episode. Now, there are people that say, okay, I want to take the next step. What should I gather? Should I do an appointment? What do they need to just have in front of them when they have, finally an appointment with someone here at Vasquez and Servi?
So sure, real quick, no one's answering phones right now, but they'll be answering phones after 8 a.m. tomorrow.
Right.
Okay. But you can imagine, for your first appointment, bring in your passport, your biographic documents, any immigration documents, any criminal documents. If you're missing anything, make the appointment anyway. We can work through that most of the time. If you're missing an immigration document, that's usually the piece of the puzzle that I may want to see that could change the evaluation of the case. But you'll get a chance to send it to me even after the appointment, so I can finish up the consultation and tell you what we can do on the case.
Okay. And if there's people listening in other states outside of Georgia, they can also consult. Now, immigration is federal law. You guys can help anybody in the United States?
We have cases from just about all 50 states, not all of them, but just about all of them.
Sure, great.
Yes.
Wow, Attorney Thad, there's so much that we could, still touch on. Of course, we're going to leave a little bit for the next show, but again, we'll be doing this content every Tuesday with the exception of next week. And then if we've got the Spanish language for your moms and dads, they probably already know us. So we're starting off with this English language podcast. Vasquez and Servi, they're here in the heart of Atlanta off of 85. Give us a little bit of info on where the office is located, the hours, and how they can make contact with you guys.
Sure. Just call our office for the appointment. You can also visit the website and you can book an appointment directly there. But if you call the office and say that you saw this podcast, and we'll give a discount for the appointment. We are on the 85 southbound side, right on the access road in between Chambly, Tucker, and Shelford, 3190 Northeast Expressway Northeast. We take appointments telephonically, in person, video. So you name it, we can do it.
There's no excuses. And just remember, it's very important for you to know exactly who is handling your immigration case. It could mean the difference between a family being separated, people being deported, people being accused of fraud. So very, very important. Honesty, more than anything. You guys have 30 years experience. So remember, we're hoping that this is going to change lives. People are going to understand, wow, I thought that I could help my parents. I thought it was easy. I thought being a citizen opened every single door, every single pathway. It's not that easy, but when you have the perfect help and people with experience, people that are honest, like Vasquez and Servi, the path will be much clearer. At least if you have to wait, because some people, you do have to tell them, right, Attorney Thad, listen, maybe not right now, maybe in a couple of weeks, maybe in a couple of years, but definitely before making any moves, please don't go to these notaries. Don't go to these, bilingual paper fillers. It takes way more than just being bilingual. A lot of you guys that have DACA that have been doing your own renewals, great. But some people are getting notices saying, hey, I need more evidence. And they've been renewing DACA forever. We have a client, we have a mutual client from where I work on the afternoons that are like, listen, my DACA was expired because they asked for additional evidence and they didn't have it. He doesn't have a criminal record. Things happen, attorney, and it's better to have the representation that you need rather than just advice from someone who's bilingual. It takes way more than that.
Exactly, and we are very thorough. We will shoot straight with you. We've been doing this for 30 years, and our hearts are in this.
Yeah. Of course. So thank you, everyone. Muchísimas gracias por haber compartido. Thanks for sharing our English language podcast. This is our first episode. Please keep sharing. Please keep watching it over and over. We know it's a little bit long, but we knew that there was a lot to touch on, and we have plenty more for our next edition, the week after next. So Brenda Bueno, Attorney Thad Serby, muchas gracias. Thank you, everyone. And hey, there's no other way to go than forward together.
Absolutely. Thank you, everyone, and thank you, Brenda.
Thank you. We'll see you guys on the next episode.